She filed first, and suddenly every decision feels like you're on defense. You thought you had time to regroup, to weigh your options, to brace for impact. Instead, she took the initiative, and now the ball's in her court. But here's the twist. Playing catch-up is exactly what costs you. When your ex files, she gains the power to set the pace, lock down temporary orders, and frame the narrative, while you scramble to respond. What no one tells you is that those early skirmishes aren't minor. They determine who has access to bank accounts, who pays support, and even who gets the keys to the house for the next few months. Miss the chance to push back immediately, and you'll end up stuck with decisions made without your input. The worst part? Those orders rarely go away. Once a judge signs off, they become the foundation for final settlements, and courts almost never rewind the clock. That's why you need to flip the script. Instead of waiting for her to draw the lines, you must step up with your own set of moves. Moves that freeze assets, reveal the real numbers, and protect your income from day one. In the next few minutes, we're going to lay out 6 critical strategies that transform "she filed first" from a disadvantage into an opportunity. Each one is designed to lock in your rights, cap your liabilities, and make sure you're not paying thousands more just because you hesitated. If you're staring at divorce papers with your name on them, listen closely, because the window for action opens the moment she files, and it closes fast. You thought letting her file first would give you time. Instead, it handed her the keys to the courthouse and the power to lock down temporary orders without your input. The very first move you need is to file your own counter-request for temporary orders immediately after she files. Don't wait for her summons to arrive or for a court date. Go on offense. Ask the judge to freeze assets, set provisional support levels, and establish a parenting plan that reflects your routines. Here's why it matters. If she's the only one asking for orders, the court can issue a unilateral freeze on bank accounts, prohibit transfers on real estate, and even assign primary physical custody, making you the non-custodial parent by default. That means she controls the money, the home, and the day-to-day schedule. Any joint credit card you thought you could use to manage bills gets shut down. The minute-long handshake agreements you had about splitting costs mean nothing once a judge stamps temporary restraining order. By filing your own temporary requests, called cross-petitions in many courts, you force the judge to consider both sides of the first hearing. You get a say in who pays what support, which accounts get frozen, and how custody looks while divorce moves forward. Even if you plan to contest the final divorce terms, these provisional orders set the stage. Judges rarely upend their own temporary decisions later. So what you lock in now has a huge impact on your cash flow and living arrangements for months, sometimes years, to come. Think of this as a financial and emotional seatbelt. It keeps you from being tossed out of the driver's seat just because she pulled the parking brake first. And beyond asset freezes, it lets you negotiate support amounts on a level playing field, capping what you pay until a full hearing, rather than letting her define the numbers unchallenged. Next, we'll look at how demanding full financial disclosure right out of the gate prevents hidden surprises that can cost you thousands down the road. Demanding full financial disclosure from day one is your next power move. When she files first, she controls the story, what assets exist, what debts loom, and how income is portrayed. If you let that narrative go unchallenged, you'll end up agreeing to support or property splits based on half-truths. That's why you must insist the court order her to produce everything. Tax returns for the last 3 to 5 years, recent bank and brokerage statements, retirement account summaries, mortgage and loan documents, even credit card bills. Here's the catch. Courts move fast on temporary orders, and judges often rely on the petitioner's numbers when making quick decisions. If she claims her income is $8,000 a month, but only shows you last year's W-2, you won't know about a 6-figure bonus or side gig that pushes her into a higher support bracket. Conversely, she could underreport debts to make her financial situation look dire, prompting the court to award her a larger share of marital assets. Without full disclosure, you're negotiating blind, and that almost always ends in overpayment. By filing your immediate request for detailed financial affidavits, you put her figures under a microscope. The court will give her a deadline, often 30 days, to submit verified documents, and she risks sanctions for noncompliance. Once you have those records, you can spot inflated expenses, hidden accounts, or unreported income, and your attorney can file objections or motions to correct the record before temporary support and property orders become locked in. This is more than paperwork. It's insurance. It transforms her claims from vague assertions into hard data you can cross-check. And when both sides stand before the judge with the same level of transparency, you're not at the mercy of an uneven playing field. You can negotiate provisional support rates that reflect true income, split debts fairly, and eliminate surprises that could drain your savings. Next, we'll cover how to lock in provisional spousal and child support amounts before anyone else sets the numbers, giving you control over what you'll pay until final judgments come down. Locking in provisional spousal and child support early can save you thousands. When she files first, the court may issue a temporary support order based solely on her request, often using her numbers without your input. If you don't act, you could be ordered to pay full child support plus spousal support at rates you haven't had a chance to contest. Those checks start clearing your account immediately, and judges rarely reduce temporary awards once they're in effect. Instead of waiting for her motion, you file your own request for temporary support on the same day you file your counterpetition. You present your accurate income figures, propose realistic custody schedules, and let the judge compare both sides side by side. By doing this, you cap what you'll pay from day one. You might end up with joint custody days instead of hers exclusively, which can reduce child support by hundreds per month. Or you'll set spousal support at a figure that reflects your actual earning gap, rather than whatever number she unilaterally suggests. Here's how it works in practice. Imagine she claims monthly expenses of $6,000 and asks you to cover $2,500 in spousal support. You provide your own breakdown, say $3,500 in necessary living costs, backed by documentation. The judge sees the discrepancy and orders a midpoint, such as $1,200. That's $1,300 less per month than what she initially asked for, saving you over $15,000 a year. If you hadn't filed your request, you'd be writing checks for the full $2,500 until your next hearing, by which time your savings could be gone. It's critical to submit proposed support worksheets and financial declarations at the first hearing. Once the judge signs off on a temporary order, it becomes the baseline for final support calculations. And because modifying existing orders is much harder than creating them, you lock in those favorable terms. You're not just reacting. You're shaping the financial landscape while the judge's pen is still fresh. Next, we'll look at protecting your retirement nest egg with a QDRO, so your long-term savings can't be raided during these early proceedings. Securing a qualified domestic relations order, QDRO for short, at the start is like putting your retirement savings in a safe deposit box before the storm hits. If she filed first, she could seek temporary orders that freeze or even reassign your 401k, IRA, or pension assets without warning. But a QDRO, filed alongside your counterpetition, tells the court and plan administrators exactly how those accounts are to be divided, preventing unauthorized withdrawals and ensuring any split follows the rules you've proposed. Without a QDRO, your ex, or the court, can treat your retirement like liquid cash, triggering early withdrawal penalties or using your portion as leverage in spousal or child support calculations. By submitting a draft QDRO as part of your temporary orders, you lock in the division formula up front. This forces the judge to acknowledge your terms at the very first hearing, and it signals to plan administrators that no transfers should occur without following those precise terms. Here's why that matters. Retirement accounts grow over time and are often the largest single asset you own outside of the house. If she convinces the court to freeze or tap into your pension under emergency claims, such as needing funds for immediate support, you could see thousands shaved off before your counsel even has a chance to argue. A properly structured QDRO, however, prevents any movement outside the prescribed split, protecting both your principal and the tax advantage growth. In addition, filing the QDRO early gives you time to address any technical issues, like plan-specific language or administrative delays, while you still have leverage. If her lawyer questions your QDRO's wording, you can negotiate modifications before final orders are issued, rather than scrambling to correct mistakes after the accounts have been divided. Finally, courts view early QDROs favorably because they promote clarity and reduce post-divorce litigation. By taking this proactive step, you not only safeguard your nest egg, you also strengthen your position in negotiations, demonstrating to the judge that you're organized and serious about fair, enforceable division. Next, we'll look at how requiring a life insurance policy or bonding can guarantee those support obligations get paid, even if circumstances change. You can't assume alimony and child support will arrive on time just because they're court-ordered. If your ex faces financial trouble down the road, job loss, health crisis, or even intentional non-payment, you could be left chasing payments while your own bills pile up. That's why move number 5 is to ask the court to require a life insurance policy or posting of a surety bond securing those support obligations immediately. Here's how it works. You petition for a term in your temporary orders that your ex maintain a life insurance policy with you or your children as beneficiary, in an amount covering the total support due until final judgment. Alternatively, the court can require a bond, a guarantee from a third-party insurer that steps in if payments stop. This isn't about distrust. It's about making sure the plan B for support is already in place before any gaps appear. Consider this scenario. She files first, and 3 months in, she loses her job. Without a safety net, she halts alimony or struggles with child support, forcing you to file contempt motions or emergency hearings. Meanwhile, you're scrambling for legal fees and watching your own expenses mount. But if a bond or life policy is in place, you can file a simple claim and receive payment. No wait for protracted court battles. Securing insurance also sends a signal to the court. You're not asking for sympathy. You're demanding responsibility. Judges respect parties who anticipate risks and move to mitigate them. It reduces the court's administrative burden for future enforcement, and it protects the children from sudden financial shocks. Don't assume your ex will agree voluntarily. Make it part of your counterpetition for temporary orders. Provide sample policy terms or bond quotes to show it's practical, and attach a clear explanation of the coverage needed. Once the judge signs off, the requirement kicks in immediately, long before final settlement, locking in a financial backstop that resists life's unexpected turns. Next, we'll cover how negotiating an early, favorable parenting plan can actually lower your support obligations by increasing your custodial days from day one. Propose a parenting plan that maximizes your custodial time from the outset, because every extra overnight with your child can shave hundreds off your monthly support obligation. When she files first, the court may default to awarding primary physical custody to her, especially if you haven't presented your own schedule. By negotiating a shared or near-equal schedule, week on/week off, extra midweek visits, more holiday splits, you reduce the days she can claim for support calculations and increase your own. Think ahead to the formulas your jurisdiction uses. Child support is almost always tied to the number of overnights. One extra weekend can mean 4 fewer support days on the calendar. An additional week during summer can shift annual calculations in your favor. If you show the court a detailed proposed plan, complete with calendars, school schedules, and transportation logistics, it demonstrates that you're not only willing but fully prepared to share parenting responsibilities. Even temporary plans matter. Seek interim custody orders that reflect this balanced approach while negotiations continue. Judges often look for stability and routine when crafting temporary schedules. A clear, realistic schedule you present can become the temporary order, and it's rare to see substantial changes at final hearings unless there's a dramatic shift in circumstances. Beyond support savings, this move shows the court you prioritize your child's best interests, a factor judges weigh heavily. It positions you as a cooperative, responsible parent, which can influence other decisions, such as the level of supervision required or the allocation of extracurricular costs. Remember, these negotiations happen fast, so bring journal entries or logs of your past involvement, school pickups, doctor visits, bedtime routines, to prove you're already living the plan you propose. The early hearing is your chance to lock in a pattern that benefits both your relationship with your child and your financial bottom line. By taking the initiative on custody now, you not only protect your parental rights, but also take direct control over how much child support you'll owe, transforming She Filed First from a financial disadvantage into a strategic opportunity. By the time the ink dries on those temporary orders, you'll already have laid the groundwork for how the rest of your divorce plays out, financially and emotionally. Filing your own counterpetition ensures you're not just reacting to her first move. You're setting the rules from day one. Insisting on full financial disclosure keeps surprises off the table. Locking in provisional support caps what you pay. A well-drafted QDRO shields your retirement. A life insurance policy or bond guarantees payments arrive on time. And a parenting plan that maximizes your custodial days shrinks child support before you even sit down for final negotiations. None of these steps require fighting dirty. They demand foresight, documentation, and the willingness to engage the court on equal footing. Because once she files first, the clock is ticking. Miss the window for any one of these moves, and those thousands you could have saved start slipping through your fingers. So if you're staring at divorce papers right now, don't just brace for impact. Move first. Seize control of the process, protect your assets, and turn her advantage into yours. The moment she filed was your moment to change the game. Make it count.